great about this. What we've discovered is this. We've had 3 school board investigations. The school board's investigators were investigating the investigators, okay? We've had 1 Bradenton Police Department investigation, and we've been a year taking depositions. There was not ever one piece of evidence, and I'm saying not one piece of evidence that Mr. Frazier ever had sexual relations with anybody or touched any girls in intimate locations. Never. Throughout all of this discovery, it's never one piece of evidence whatsoever. And I think that's important because the general perception out there is different from what actually the charges were. The charges were simply a battery. And that's, you know, I've used that demonstration before, but that's that, okay? So that's important. And I think that, in my opinion, this investigation was fraught from the beginning. And I'll tell you why. The way it was handled by the Bradenton Police Department, I'll give you some specifics on that. First of all, they are the ones that put all the evidence together and give it to the state attorney. And I commend the state attorney, Heather, and the rest of them, Keith, because they really salvaged what they got. Because there was information that was given to the Bradenton Police Department that later was proved false. There was an affidavit signed by one of the main investigated officers that one of the witnesses said was false. He signed it under oath. Also, I found out during the investigation that the investigators were suggesting all of these facts and things to these witnesses all the time and lying to them, saying that the Frazier's phone had been tapped and that this person said this and this person said that. So they lied to them and they put words in their mouth. It's like a computer. If you put trash in a computer, you get trash out. And I think that's really what happened with some of these particular cases. And so I really believe that the reason that we're here today is because the investigation was flawed from the beginning by the Bradenton Police Department. And I can defend that forever. So that's my...
But yet, despite all this, why didn't you just fight to the end? Why did you just agree to this?
It's very simple. It's very simple. Mr. Frazier is trying to work hard. He's run out of funds. There's no more funds out there to fight the thing. And it's been a very expensive battle. And I've been doing this 45 years. I've been there with great cases and lost, and I've been there with terrible cases and won. So the bottom line of litigation is it's a crapshoot. And so do you take a chance when you get probation? No, it's not. It's stupid. It would be stupid. And remember, they dropped 4 charges. Okay, 3 of them are batteries. So I wrote that over here for you. But he pled no contest to 4 batteries, but they dropped 3. Almost half of them were dropped, and that's I thought was very important that they would drop these charges. They dropped charges in Mr. Gagnon's case, as y'all well know, in those cases. So in the end, somebody will have to look back and say, what was all this about, really? Okay, and I think that's a significant observation that we have to make. But I'm real happy that they'll step up and drop charges, and that's unusual. The state attorney doesn't drop charges because it sort of counts against their record in Tallahassee when it comes to funding. So I thought that was the thing that sort of tipped it over as far as I was concerned. He did not admit any guilt. It's a no contest best interest plea. He's home all the time anyway. He's home with his family and his kids. So for him, house arrest was not, I didn't think was a big deal. And he was home quite a bit anyway, and he can still go to work. He works, and he's working regular now. And so it really was in his best interest, both financially, emotionally. It's been taking a toll on him too, you know, and on me too. But that wasn't a consideration. I just threw that in, you know, for laughs. But I think it was clearly a best interest result, and it was a good result when you get the state to drop charges. And I think that's really what we have to talk about. What comes out of this plea today is no admission of guilt, drop charges, probation. That was always the headline of the whole thing.
What about the fact that you said the victims' families are still reaching out to him? Can
They
you
are.
talk about that?
Yeah, I sure can. One of the victim's boyfriends, who's going to be the father of her child, confronted him at a 7-Eleven just the other day and said, "Oh boy, we're going to get $400,000 from you in the big suit." As most of you know, I've made a big deal out of that. that there's a lot of motive was money in this case, because the one victim has already notified the school board that they're going to file suit. Okay, and he said, we're going to get a lot of money out of you, and I can't wait to be spending it. And then the mother goes over to his place of work. Well, you know, then they'll claim he's harassing them. So that's the only thing about the plea that I had difficulty with. That's why I insisted that we put willful in there, because it can't be just passing on the road, because Mr. Frazier lives in Palmetto. They live in Palmetto, that one family, and so we got to stay away from that. And I was very concerned about the one girl, because in the probable cause affidavit, the law enforcement officer, Mr. Marinas, said that this girl said that he pulled her pants down. And I thought, man, that's going to be a hard one to overcome. But when I took her deposition, you know what she said? She said, I never said that, Mr. Mulock. That's not true. She said, that's false. I said, he swore to it in the affidavit. And she said, no, that's false. She said, and she went on to say, you know, Mr. Frazier's a good guy, you know. So these are the kind of things that came out later that goes back to my statement that I think the Bradenton Police Department's investigation was flawed from the very beginning. Because when you try to put words in people's mouths, and you know, when you get them under cross-examination on depositions, sometimes it doesn't wind up that way. And that's really what happened to a lot of these cases. We discovered a lot of information that we were able to give to the state attorney. When they looked at it, they thought, you know, there's some issues here with some of these alleged victims. And so we got a battery, we got misdemeanor, not a huge deal. There's a lot of battery misdemeanors every day, but I think it was a good result all the way around. We cut down the litigation. You know, we had a lot set between now and June with the trials. There's going to be 8 trials. As y'all know, I won that severance. So all in all, for the court system, and the state attorneys did a very good job. And I'll tell you, I think they salvaged what they got. If it hadn't been for them putting things together the way they did, Heather Doyle's an excellent prosecutor, but she did a lot with the whole thing that I think had problems from the beginning because of the way the investigation was handled. And so that's just my comments. I think all in all, it was a best interest plea for everybody, you know.